Hello, welcome to the series of IPC. These are read-throughs of the sections and provisions of the Indian Penal Code. In this video, we are going to see Chapter 4, General Exceptions. General Exceptions reads from Section 76 to 106. Section 76. Act done by a person bound or by mistake of fact believing himself bound by law. Nothing is an offence which is done by a person who is or who by reasons of a mistake of fact and not by reasons of a mistake of law in good faith believes himself to be bound by law to do it. Illustration. A soldier fires on a mob by the order of a superior officer in conformity with the commands of the law. A has committed no offence. B. An officer of a court of justice, being ordered by that court to arrest Y and after due enquiry, believing Z to be Y, arrest Z. A has committed no offence. Section 77. Act of judge when acting judiciously. Nothing is an offence which is done by judge when acting judiciously in the exercise of any power which is or which in good faith he believes to be given to him by law. Section 78. Act done pursuant to the judgment or order of court. Nothing which is done in pursuant of or which is warranted by the judgment or order of a court of justice, if done while such judgment or order remains in force, is an offence. Notwithstanding, the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. Section 79. Act done by a person justified or by mistake of fact believing himself justified by law. Nothing is an offence which is done by any person who is justified by law or who by reasons of a mistake of a fact and not by reason of a mistake of law in good faith believes himself to be justified by law in doing so. Illustration. A sees Z commit what appears to A to be a murder. A in the exercise to the best of his judgment, exerted in good faith of the power which the law gives to all persons of apprehending murders in the fact, seizes Z in order to bring Z before the proper authorities. A has committed no offence, though it may turn out that Z was acting in self-defense. Section 80. Accident in doing a lawful act. Nothing is an offence which is done by accident or misfortune and without any criminal intent or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Illustration. A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offence. Section 81. Act likely to cause harm but done without criminal intent and to prevent other harm. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. Explanation. It is a question of fact in such a case whether the harm to be prevented or avoided was of the nature and so eminent as to justify or excuse the risk of doing the act with the knowledge that it was likely to cause harm. Illustrations. A. The captain of a steam vessel suddenly and without any fault or negligence on his part finds himself in such a position that before he can stop his vessel he must inevitably run down a boat. B. With 20 or 30 passengers on board unless he changes the course of his vessel, and that by changing his course he must incur a risk of running down a boat with only 2 passengers on board, which he may possibly clear. Here, if A alters his course without any intention to run down the boat C and in good faith for the purpose of avoiding the danger to the passengers in the boat B, he is not guilty of an offense, though he may run down the boat C by doing an act which he knew was likely to cause that effect, if it be found as a matter of fact that the danger which he intends to avoid was such as to excuse him in incurring the risk of running down the boat C. A. In a great fire pulls down houses in order to prevent the conflagration from spreading. He does this with the intention in good faith of saving human life or property. Here, if it is found that the harm to be prevented was of such a nature and so imminent as to cause A's act, A is not guilty of the offense. Section 82. Act of a child under 7 years of age. Nothing is an offense which is done by a child under 7 years of age. Section 33. Act of a child above 7 and under 12 of immature understanding. Nothing is an offense which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge of the nature and consequence of his conduct on that occasion. Section 84. Act of a person of unsound mind. Nothing is an offense which is done by a person who, at the time of doing it, by reasons of unsoundness of mind, is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. Section 85. Act of a person incapable of judgment by reasons of intoxication caused against his will. Nothing is an offense which is done by a person who, at the time of doing it, is by reasons of intoxication incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Section 86. Offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. Section 87. Act not intended or not known to be likely to cause death or grievous hurt done by consent. Nothing which is not intended to cause death or grievous hurt and which is not known by the doer to be likely to cause death or grievous hurt is an offense by reasons of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reasons of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Illustration. A and Z agrees to fence with each other for amusement. This agreement implies the consent of each to suffer any harm, which in the course of such fencing may be caused without foul play. And if A, while playing fairly, hurts Z, A commits no offense. Section 88. Act not intended to cause death. Done by consent in good faith for person's benefit. Nothing which is not intended to cause death is an offense by reasons of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith, and who has given consent, whether expressed or implied, to suffer that harm or to take the risk of that harm. Illustration. A. A surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under a painful complaint, but not intending to cause Z's death and intending in good faith Z's benefit, performs that operation of Z with Z's consent. A has committed no offense. Section 89. Act done in good faith for benefit of child or insane person by or by consent of the guardian. Nothing which is done in good faith for the benefit of a person under 12 years of age or of unsound mind by or by consent either expressed or implied of the guardian or other person having lawful charge of that person is an offense by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to that person, provided proviso first, that this exception shall not intend to the shall not extend to the intentional causing of death or to the attempt to cause death. Secondly, that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. Thirdly, that this exception shall not extend to the voluntary causing of grievous hurt or to the attempting to cause grievous hurt unless it be for the purpose of preventing death or grievous hurt or the curing of any grievous disease or infirmity. Fourthly, that this exemption shall not extend to the abatement of any offense, to the committing of which offense it would not extend. Illustration: A, in good faith, for his child's benefit, without his child's consent, has his child cut for the stone by a surgeon, knowing it to be likely that the operation will cause the child's death, but not intending to cause the child's death. A is within the exception in as much as his object was to cure the child. Section 90. Consent known to be given under fear or misconception. A consent is not such a consent as is intended by any section of this code if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reasons to believe that the consent was given in consequence of such fear or misconception, or consent of insane person. If the consent is given by a person who, for unsoundness of mind or intoxication, is unable to understand the nature and consequence of that to which he gives his consent, or consent of child, unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. Section 91. Exclusion of Act, which are offences independently of harm caused. The exceptions in section 87, 88, 89 do not extend to act which are offences independently of any harm which they may cause or be intended to cause or be known to be likely to cause to the person giving the consent or on whose behalf the consent is given. Illustration: causing miscarriage unless caused in good faith for the purpose of saving the life of the woman is an offense independently of any harm which it may cause or be intended to cause to the woman. Therefore, it is not an offense by reason of such harm, and the consent of the woman or of her guardian to the causing of such miscarriage does not justify the act. Section 92. Act done in good faith for benefit of a person without consent. Nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith, even without the person's consent, if the circumstances are such that it is impossible for that person to signify consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him from whom it is possible to obtain consent in time for the things to be done with benefit. Provided, first, that this exception shall not extend to the intentional causing of death or the attempting to cause death. Secondly, that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death or for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. Thirdly, that this exception shall not extend to the voluntary causing of hurt or to the attempting to cause hurt for any purpose other than preventing of death or hurt. Fourthly, that this exception shall not extend to the abatement of any offense, to the committing of which offense it would not extend. Illustration: Izet is thrown from his horse and is insensible. A surgeon finds that Izet requires to be trepanned. A, not intending Izet's death but in good faith for Izet's benefit, performs the trepann for Izet's before Izet recovers his power of judging for himself. A has committed no offense. B. Izet is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Izet, but not intending to kill Izet and in good faith intending Izet's benefit. A's ball give Izet a mortal wound. A has committed no offense. C. A surgeon sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply to the child's guardian. A performs the operation in spite of the entreaties of the child, intending in good faith the child's benefit. A has committed no offense. D. A is in a house which is on fire with Izet a child. People below hold out a blanket. A drops the child from the housetop, knowing it to be likely that the fall may kill the child, but not intending to kill the child and intending in good faith the child's benefit. Here, even if the child is killed by the fall, A has committed no offense. Explanation: Mere pecuniary benefit is not benefit within the meaning of sections 88, 89 and 92. Section 93. Communication made in good faith. No communication made in good faith is an offense by reasons of any harm to the person to whom it is made, if it is made for the benefit of that person. Illustration: A surgeon in good faith communicates to a patient his opinion that he cannot live. The patient dies in consequence of the shock. A has committed no offense, though he knew it to be likely that the communication might cause the patient's death. Section 94. Act to which a person is compelled by threats. Except murder and offences against the state punishable with death, nothing is an offence which is done by a person who is compelled to do it by threats, which at the time of doing it reasonably cause apprehension that instant death to the person will otherwise be the consequence, provided the person doing the act did not of his own accord or for a reasonable apprehension of harm to himself short of instant death place himself in situation by which he became subject to such constraint. Explanation 1. A person who of his own accord or by reasons of a threat of being beaten joins a gang of dacoits, knowing their character, is not entitled to the benefit of this exception on the ground of him having been compelled by his associates to do anything that is an offense by law. Explanation 2. A person seized by a gang of dacoits and forced by threat of instant death to do a thing which is an offense by law, for example, a smith compelled to take his tool and to force the door of a house for the dacoits to enter and plunder it, is entitled to the benefit of this exception. Section 95. Act causing slight harm. Nothing is an offense by reason that it causes, or that it is intended to cause, or that it is known to be likely to cause any harm, if that harm is so slight that no person of ordinary sense and temper would complain of such harm.